I'm Joel Ankney. I'm a lawyer who helps people buy and sell small businesses, and I'm the author of the book, Here's the Deal, Everything You Wish a Lawyer Would Tell You About Buying a Small Business. Earlier this year, I was invited to speak to the Entrepreneurship Through Acquisition class at the Columbia Business School about the legal process of buying a small business. And I'm making this video to share with you the presentation that I gave to the ETA class because I think the information is relevant for anybody who's thinking about buying or even selling a small business. There are also a number of ancillary closing documents that need to be drafted, reviewed, and negotiated prior to closing. The 6 ancillary closing documents identified on this slide are the seller financing promissory note, the personal guarantee that the seller may require the buyer to provide to the seller financing promissory note, the bill of sale, which is a title transfer document for the tangible assets, a proprietary rights assignment agreement. This is a title transfer document to transfer the intangible assets, the intellectual property, the trademarks, copyrights, patents, trade secrets, know-how, etc. An assignment and assumption of contracts. If there are contracts that are being transferred as part of the assets, for example, significant contracts with vendors or suppliers or manufacturers, significant contracts with clients and customers. This is the document that will transfer title to those contracts from the seller to the buyer. If there is a brick and mortar lease, for example, that needs to be transferred from the seller to the buyer as part of the transaction, there will be a separate lease assignment and assumption agreement. There will be a separate non-competition and non-solicitation agreement that the buyer will require the seller to sign at closing. If there is a post-closing escrow for indemnification claims, there will be a separate escrow agreement that's signed by the buyer, the seller, and the escrow agent. There is also typically a consulting agreement or transition agreement that is signed at the closing where the seller promises and agrees to provide certain transition services to the buyer after closing. Corporate resolutions that need to be drafted and signed at closing that authorize either the purchase or the sale of the business. There will be some certificates that are drafted and signed at closing. A certificate called a bring down certificate, for example, which basically says that if the asset purchase agreement was signed prior to the closing, maybe a couple of weeks or a month prior to the closing, that the representations made in the asset purchase agreement were true not only when the asset purchase agreement was signed, but they're also still true on the closing date. There will also be an entire loan packet if there is a lender involved, a packet of loan documents provided by the lender that will have to be signed by the buyer, who is the borrower, at the closing. You may wonder why there are all these different ancillary documents, why the asset purchase agreement doesn't accomplish what these ancillary closing documents accomplish. One of the reasons why some of these documents are necessary is because they are title transfer documents. For example, when you own a car or a house and you want to sell that car or the house, there is a title transfer document that already exists. The car has a title to it and a house has a deed to it. And so when you sell a car or a house, one of the things that you deliver to the buyer is the signed title to the car or a new deed that's signed by the seller to transfer title over to the buyer. In an asset purchase transaction, there are no title documents, and so we have these ancillary closing documents to transfer title to certain categories of assets. Another reason why we have separate ancillary closing documents is because if a dispute arises after closing around one issue, for example, if the buyer thinks that the seller is violating the non-competition restriction, we'd much prefer to bring a separate non-competition and non-solicitation agreement before a court than to bring the whole asset purchase agreement before the court. Another legal reason for having separate documents is that there is an old rule, and it may or may not apply in certain states, that if one provision of a contract is invalid or unenforceable, that makes the entire contract unenforceable or invalid, and we want to avoid that. There are other ways we try and avoid that with some of our drafting language in the asset purchase agreement as well. Another reason for having a separate ancillary closing document related to the transfer of trademark trademarks and copyrights is because if a trademark or copyright is registered with the federal government, part of the transfer of that trademark or copyright involves recording the transfer document with the U.S. Patent and Trademark Office or the U.S. Copyright Office. And again, we don't want to record the entire asset purchase agreement because the recorded document becomes public record and we don't want people to be able to see all the terms of the transaction. So instead, we have this separate document that we can record, and the public can only see the information that's in this short ancillary closing document. Thank you for watching my presentation. If you have more questions or want to learn more about the process of buying or selling a small business, you can see my contact information here on this last slide. If you want to buy my book or listen to the audiobook, you can find the print book on Amazon and the audiobook on Audible. I also maintain a blog at my website, so if you have other questions, you might look there first to see if you can find an answer there. Thanks.